We will be getting started momentarily.
Good afternoon. I am Chilton Varner, the president of the Supreme Court Historical Society. It's my honor and pleasure to welcome you to this virtual conversation this afternoon, delivered by Mark Killenbeck and Farah Peterson. As I've said to some of you in other previous virtual presentations, the Society and its staff have been working diligently to keep the energy level at the level that we are accustomed to with the Supreme Court Society. We're working hard to adapt as the pandemic is proving exactly how stubborn it can be. While we would love to be holding events in person, today we are being routed to the virtual presentation, and we have presented previous lectures in the same way. We found out that the virtual approach does carry some advantages. For example, it reaches a much broader audience because our membership is scattered across the country. Similarly, it allows us to archive for future use the very fine programs that the Society has sponsored. So given these advantages, even when we are able to return to in-person programming in the Supreme Court chamber, we are also going to continue to offer a virtual menu. Today is October 4th. More to the point, it is the first Monday in October. As you are aware, the first Monday in October is when the Supreme Court traditionally starts its new term. It is also fitting, I think, for the Supreme Court Historical Society to present today's program as the Supreme Court term of the 1821 year. We will do that as the current court launches today. It's 2021 term. Professors Peterson and Killenbeck are going to talk for about 60 minutes between them. They will then pause and they will take comments and or questions from our virtual audience. If you have a question or a comment, please transmit it to the Society through the Q&A feature of your Zoom connection. Jim Duff, the Society's executive director, will be reviewing all of those questions and comments and will put as many as is reasonably possible in front of our two professor speakers today. About those two speakers, Professor Farah Peterson is a distinguished legal historian who clerked for Justice Breyer on the Supreme Court and for Judge Guido Calabrese on the Second Circuit Court of Appeals. She holds both a PhD in history from Princeton and a JD degree from Yale Law School. She currently is a professor of law at the University of Chicago Law School. Professor Mark Killenbeck is the Wiley Davis Distinguished Professor of Law at the University of Arkansas. He is an expert on the Constitution and on American legal history. He has been a fine friend of the Supreme Court Historical Society. Indeed, he delivered the inaugural first Monday lecture in the Supreme Court chamber on October 7th. 2019, an event which was sponsored by Justice Breyer as the host. Professors Peterson and Killenbeck previously collaborated and conversed in a discussion of McCulloch v. Maryland. That exchange was hosted by C-SPAN as the first session in its second landmark case series. So I'm delighted to welcome Professors Peterson and Killenbeck to the Society's virtual platform. We are grateful for their scholarship, for their interest and their willingness to share with the Society. So professors, you're now in charge, so take it away. And thank you again for helping us today.
Well, thank you very much. And it's just a delight to be together with Mark again. This is, as you said, it's a re-encounter. We were together for a delightful experience. And for me, it was the first time being on TV. So it was very exotic and exciting. And we got through that together. So nothing can scare us now. And once again, we're talking about Marshall. And I think that because we have an audience that is mixed with some students, some non-lawyers, lots of lawyers, some historians, it makes sense to just start from the basics. And I think that would also be the most fun. Let's put 1821 in its context. To do that, it's important to talk about who is Chief Justice John Marshall? Who are we talking about? And when I say who is he, I mean, who was he in his time? He wasn't the guy who is represented in the wonderful monumental statue that anchors the first floor of the Supreme Court building. He didn't have that stature during his lifetime, and nor did the institution that he represents. And you know, to highlight that fact, nothing's better than pointing out that he wasn't even the first pick for the job. When John Adams' first pick was the former Chief Justice John Jay, who went through the entire confirmation process and then responded to the letter notifying him that he had been appointed Chief Justice with an immediate decline, saying that he feared that the court would never obtain the energy, weight, and dignity that it would need in order to take the place that it would require in American public life in order to do the kind of job it needed to do. So he declined because he basically didn't have faith in the likelihood that the Supreme Court would ever become a force in American public life. So one thing that Mava Marcus's wonderful collection of early Supreme Court documents also reveals is that for many people, the Chief Justice, John Marshall, wasn't even the second choice. There was a lot of grumbling among the Federalists about, well, why didn't he appoint Ellsworth? Poor Ellsworth was looked over by John Adams. So he took the bench, disliked by many, even in his own party, and the second choice of the president who appointed him. He took a position that was understood by a person who had held it before to be an underdog position, a position that had little actual power. And then he held that position opposite a chief executive that loathed him. He swore in Thomas Jefferson to the presidency, and the two of them had personal animosity between them, but that was nothing compared to the antipathy they shared toward each other's philosophies of government. And that would never go away. So usually when we introduce students to the great Chief Justice John Marshall, we do so by teaching them Marbury v. Madison. And for those of you who don't know the case, and I saw a couple of names, including my cousin, thank you for showing up, Nikki, who are not lawyers. Marbury v. Madison was a case that the facts were, could a person who had been appointed by the outgoing President John Adams but whose commission had never been delivered, ask the Chief Justice of the Supreme Court to force the incoming president and his minister, his Secretary of State, James Madison, to deliver the commissions, even though they were disinclined to do so. And in Marbury v. Madison, Marshall wrote a tricksy opinion in which he said, it is emphatically the province and the duty to say of the judicial department to say what the law is, and only a knave would fail to deliver these commissions. Jefferson really ought to deliver these commissions because it is the law that Marbury is owed this commission. But unfortunately, there's nothing I can do about it because the section of the Judiciary Act that gives him the right to appeal to me directly for a writ to tell Madison to do this is unconstitutional. So he said, emphatically, and always mistrust someone who uses the word emphatically, right? Emphatically, it's my job to say what the law is. And he said it in the most obnoxious way possible. But then he used a procedural trick to get out of actually trying to force the instrumentalities of government to do his bidding, because he knew that there was nothing he could say or do to make the executive branch do what he said. It was, as Kent Neumeyer puts it, establishing a beachhead in hostile territory. It was Marshall, establishing a position on the power of the judiciary in a very hostile climate, political climate, and establishing that in the hopes that the climate would change. So we teach that case, Marbury v. Madison, as though it established something about federal power, but there was no guarantee that he would ever be able to make good on that promise. But the climate did change. The next Jeffersonian Republicans to take the presidency were quite different political creatures. Madison took over from his mentor. He was much more nationalistic. He, well, to call Jefferson Madison's mentor is perhaps not doing justice to Madison, so set that aside, erase that from the record. But he was shaped by the experience of governance in a way that inclined him more toward nationalism than Jefferson was perhaps ever able to be shaped from his more philosophic temperament. And Madison also was a president who had to deal with the rising secessionist issues in the Northeast. He was the president who would have to deal with the Hartford Convention while trying to prosecute the War of 1812. This was a party, still Republicans, still drawing their roots to Jeffersonian republicanism and the Kentucky and Virginia resolutions, and yet they were a party of nationalists. And this was a kind of politics with which Marshall's federalism could march hand in hand. The first signal of the rapprochement between the nationalistic Republicans and John Marshall came with U.S. v. Peters, a case we don't teach. A really interesting case, a case that I wish that we could linger on because it involves piracy and impressment, and a ship being frog marched into port, and fighting between rival militia and posse comitatus of the federal government. But to make a very long story short, a privateer captured a British ship, and then proceeds of the sale were in litigation for years. And the question was, does Pennsylvania own the proceeds of the sale, or the captain who captured it? The Pennsylvania court ruled for Pennsylvania, and a US Court of Appeals authorized under the Continental Congress said it belonged to the captain. After years, the captain never got his money, and finally he appealed to the US Supreme Court for a writ of mandamus, asking Marshall's court to force the US District Court to impose, to execute a judgment in his favor. The Pennsylvania legislature exploded at this. issued resolutions saying, echoing the Kentucky and Virginia resolutions, saying that Section 25 of the Judiciary Act of 1789, the section that creates appellate jurisdiction from judgments of a state Supreme Court to the US Supreme Court, was unconstitutional. That because a state is a separate sovereign, the US Supreme Court could never tell a state what to do. And the governor of the state, Governor Snyder, even threatened to call out the militia. Chief Justice Marshall wrote a very strong opinion supporting federal jurisdiction in the case and ordering the lower federal court to support the claim of the sea captain. And it was only because James Madison signaled to the governor of Pennsylvania that he would stand behind that judgment that Pennsylvania stood down. And this was a very strong signal that things had changed at the federal level. Finally, Marshall had someone in the presidency that he could work with. And this period of calm would last for a very long time. That's not to say, however, that Marshall had no more competitors. Right? This issue of Section 25 of the Judiciary Act of 1789, the section that created appellate jurisdiction from the judgment of a high court of a state to the Supreme Court, would come back to the court again and again, almost as if Marshall had said nothing. And the next time that Marshall would have a chance to say anything about it would be 7 years later in Martin v. Hunter's Lessee. This case would also bring to the fore of our story Marshall's greatest nemesis, Spencer Roane. Arguably one of the least, one of my personal favorites, probably the least well-known, but one of the most exciting intellects of this era. He became the Chief Justice of the Virginia Court of Appeals. And the background of the case, it involved an earlier merits case called Fairfax v. Lessee that involved a question of who owned a tract of land in Virginia, whether it was people who bought it from a loyalist and his heirs, or people who took it from the Virginian government that confiscated it during the war. The facts are complicated and unimportant. The point is, Virginia had ruled in one way, and then when it was certified to the Supreme Court overturned the High Court of Virginia's ruling and sent it back. When Spencer Roane got this judgment and mandate from the Supreme Court to reverse himself, he said, now wait just a second. It didn't help that Spencer Roane remembered that a young John Marshall had argued about this very issue in the Constitutional Convention of the state of Virginia on the other side, urging people to ratify the Constitution and reassuring people that these very land claims would not be touched by ratification of the Constitution. It didn't help that Spencer Roane suspected that Marshall, even though he had technically recused himself, was as an interested party in these land claims, working behind the scenes to affect the judgment. And his signature was on the mandate, sending it back for reassessment in Virginia. And it didn't help that it violated all of his sensibilities as a good revolutionary veteran, that some of these claims had aristocratic pretensions attached to them. The claims involved, feudalistic, quit rent issues where Marshall and the other landowners were going to go around getting their vassals to give them back rent owed to them under a British lord's claims from way back in the day. In any case, Spencer Roane refused to enter the mandate from the Supreme Court. Instead, he called for oral argument that lasted 6 days, appointing amici from the leading lights of the Virginia bench on the question of whether a appeal could be taken from the High Court of a state to the Supreme Court, or whether that is unconstitutional. And then he waited for a year and a half before making his decision, not because he was unsure of how he wanted to come out on that question, but because this was during the War of 1812. And he, as a good Republican, didn't want to give aid and comfort to the Hartford Convention and the other secessionist Federalists up in the Northeast. In the meantime, he took himself to Monticello to consult with Jefferson and to reassure himself that Jefferson was on his side and engaged in correspondence with him. He took himself to White Sulphur Springs and corresponded with Monroe on the question. And after a year and a half, he came out with a decision that said very strongly, we are a sovereign state. And we deny the power of any other sovereign to dictate to us about issues that we have finally decided. It didn't help the case for Marshall that the Constitution of the United States is very vague on these questions. Marshall's position on the Supreme Court was insecure when he took it, not just because no one had yet made the major pronouncements that we teach in first year of constitutional law. It was because the document itself is rather opaque on these issues. It never says the Supreme Court shall have the power of judicial review. The Supremacy Clause is no help here. And the Virginia Supreme Court, which is made up of fabulous lawyers, made this very clear. The Supremacy Clause says the Constitution and laws made in pursuance thereof is supreme. Well, that establishes a rule of decision. That doesn't say who gets to decide what the Constitution means or which laws are made in pursuance thereof. And that stands in strong distinction to the following phrase, which says simply, treaties made under the authority of the United States are supreme. If the framers had meant to say the laws made under the authority of the United States were supreme, they could have easily said so. And so it's very easy for the Virginia Supreme Court to say, this is a compact among the states. Naturally, disagreements will arise among parties to the compact. But unfortunately, the treaty, the compact, assigns no umpire to mediate these disputes. And yes, this causes inconveniences, but the signatories to the compact must have decided those inconveniences were better than the remedy for those inconveniences. And we are bound by their decision. And it says in the Supremacy Clause that the judges of every state are bound by the Constitution, and that itself is an independent reason why we cannot follow your view of what the Constitution means, but we instead are bound by our own. So the Supreme Court of Virginia utterly repudiated the mandate from the Supreme Court. This led to another opinion, an opinion about the procedural issue. Again, Justice Marshall was recused because he was interested in the underlying land claims. But Justice Story, who wrote the opinion, admitted that Justice Marshall was strongly influential on the writing process. Justice Story answered each of these textual arguments. He answered the structural arguments. But ultimately, to the point that the Virginians had made, which had been, look at the document, we see no textual authority here. Point us to your proof that our sovereignty is overcome. He said, this is not a matter of textual proof. The nature of the document does not admit of that kind of proof. This is a document that is necessarily general. It was established in general terms, designed to account for the needs of the ages. What were the exact words? The exigencies locked up in the inscrutability of providence, of something, these broad, sweeping generalities. He said, this is a document designed to endure for the ages. And so, of course, it speaks in generalities, including in the sweep of the powers that the instrumentalities of the government it creates will exercise, including the Supreme Court. So he met them as far as he could on each of their textual arguments, including a very detailed argument about the arising under clause. But he said, I don't need to meet you there alone. The nature of the document is that it is general, is framed for general purposes, and it is not a compact of the states. It's made by the people, antecedent and anterior to the states. And it is the people's authority that creates our authority.
Let's pause for just a second and make something that we had agreed I would do, something very clear here. And that is that when she's mentioned that the opinion is by Joseph Story. Story is put on the court by James Madison. He is put on the court with the assumption that he will be one of the individuals that will be turning the court away from the direction that the Federalists wanted to take it. And the composition of the court, when we get to 1814, 1816, has changed a great deal, because we've had Thomas Jefferson putting on the court William Johnson, Brockholst Livingston, and Thomas Todd. Now, three justices that most common law students never hear of, because except for William Johnson, who's a favorite of mine. And the assumption was on the part of Jefferson that he was going to be changing the composition of the court. One of the myths that persists in American constitutional history is that it's only recently that presidents have decided they wanted to appoint people because of their adherence to presidential views. That was never true. George Washington did not go out and look for anti-federalists when he appointed the original court. John Adams did not go look for a Jeffersonian to become Chief Justice when he had that slot to fill. And in particular, he thought that William Johnson, who he was told was a really good Republican, meaning states' right person, would help start to change the course of the court. And I'm fond of calling William Johnson the first stealth nominee, because there were things in his record that Jefferson did not discover that would have showed that that's not what's going to happen. James Madison comes along as president, puts Joseph Story on the court, along with another one, that Gabriel Duval, another individual that most people don't hear. And Story, with Marshall, with Bushrod Washington, George Washington's nephew and the only holdover from the Washington the Adams administration in terms of the composition of the court. This justices starting in 1809 and even earlier in 1805 with a case that I'll mention much later, start to issue opinions that lead Jefferson to the conclusion that John Marshall has worked some sort of voodoo, has compromised and seduced these people and led them over to his side. And one of the realities of Supreme Court back then was Marshall was very, very, very interested in making certain that they all roomed together for that 1 month, usually February bleeding into March, where the court was in session in Washington, and they were together. And there was this feeling that Marshall just was an insidious force, undermining the will of these dedicated Republicans. And it turns out that the history is much more complicated than that, particularly because Marshall didn't start this, but the court began to speak with one voice. There was an opinion for the court. In the 1790s, the opinions were seriatim. Each justice issued his own opinion. I wish I could say his or her, but that was not reality back then. And so in many of the cases of 1790s, you have multiple opinions. You got to read them all to figure things out. That actually started changing in 1798, 1799. It was not John Marshall that started the transition to a single opinion, but it was Marshall that seized the voice of the court. And in virtually every decision that we'll talk about today, it's Marshall speaking for the court. The exception two big exceptions, one of which I'll get to later. But the first big exception in that line is Marshall versus Hunter's Lessee, where Story speaks to the court for the court because of the supposed conflict, not supposed, it's real, on the part of John Marshall. And so part of the story that lurks in the background of what Farah has been telling us is understanding that the court under Marshall adopted a particular view, and it was a view adopted by a disparate group of individuals with differing backgrounds, some of whom did in fact have sterling intellectual credentials and were in fact dedicated to state rights views, but understood the problem that is posed if you get a situation which is posed by the Section 25 issue lurking in Martin and again in Cohens, which we will get to very shortly, that if each individual state could go its own way in terms of its approach to what is going to be the law of the land, we are not going to have the kind of unity that is necessary to fashion a nation. The War of 1812, as she's pointed out, is a catalyst because once again we are poised with dealing with enemies external, Great Britain, and the need for national unity and the need for an effective functioning national government becomes very pronounced. And I apologize for jumping in on this, but we had agreed that we would be doing this back and forth. And it's important to understand the composition of the court that is there in 1816 and becomes the court of 1821, which we're leading toward.
Absolutely. And another sort of point about that occurred to me while you're talking is, a modern mind looking back on this period might be tempted to see this as Northern nationalism versus Southern secessionism, looking back at it through the lens of the Civil War. But that would be an absolutely inappropriate lens to take. Of course, both Marshall and the Virginians opposing him in Martin v. Hunter's Lessee are Virginians. And the first case we talked about where Section 25 became an issue was Pennsylvania, was the aggressor. We have secessionists in New England as the sort of major thorn in the side of President Madison, a Virginian. And the discussion that Justice Story is having with the Supreme Court of Virginia, where the Supreme Court of Virginia says to Justice Story, look, we understand that it's inconvenient to have different versions of constitutional law emerge from different Supreme Courts, but they understood that might be a problem and they accepted it. And he answers in his opinion, you cannot mean to suggest that they wanted a hydra of government. That would be so awful. They're in the very nature of things, somebody must be the final voice. This is an ancient conversation. This conversation goes back to revolutionary times. This was the same dispute that the colonies were having I'm sorry, there was a Zoom thing that happened that distracted me. But this is the same conversation that the colonies were having with the metropole, and seems to me to be inherent in Anglo-American law, a law that's based on local self-governance and community consensus based on local hierarchies of control, confronting the problem of massive space. What do you do with a system of law that grew up in the sort of boroughs of England and was content with, governments that expanded no further than you could shout, or that you could certainly drive, your cart and horse over the course of the 3-day journey, to a massive area like the United States. Could there be imperium and imperio? This was the conversation that the colonists were having with London. Can there be multiple sources of legislative authority? Can there be multiple versions of constitutional law? Or does there have to be one center of command and control that determines for everybody what the law is? These are conversations that crop up and reoccur again and again in the American context, have something to do with the confrontation between Jefferson and Hamilton that happens quite directly when they're both serving in Washington's cabinet about what kind of country do we want to be? Do we want to be agrarian, inward looking, and sort of focused on sort of local hierarchies in which the yeoman develops his moral capacity for self-government? Or do we want to be mercantile, credit-based empires competing with Britain and France, in which case we need to be centralized, we need to be consistent, and we need to be able to tell our creditors what to expect from one jurisdiction to the next.
The irony, of course, is that the southern states, probably the ones most interested in the economic aspect of things. If you look at American history, the divide, theoretically, Massachusetts Bay Colony, religious freedom. Virginia, the southern states, those were economic enterprises. They were set up precisely because they were going to be consumers of British goods and generators of exports to Great Britain. And so when she identifies that background there, which gets exacerbated, of course, by the War of 1812 and by previous to that by Jefferson's embargo, you start to have these issues about what voice will control. It's no accident that, of course, as we start to get into South Carolina and its particular problems in the 1820s, that economic factors underlie that, the tariff controversy and the nullification and these things that build on each other, all of which are lurking in the line of cases that lead us eventually to 1821 and
so I guess the next thing on our list to talk about is McCulloch.
That's me.
Yeah.
McCulloch versus Maryland, which is another one of those war horses that constitutional law professors teach. Okay. Now, it's the controversy is relatively familiar to people. It's the second bank of the United States. Nowhere in the Constitution does it give Congress the power to charter a corporation or create a bank. And those who were at the Constitutional Convention know that that was debated in secrecy because the convention was not public. And a provision that would have allowed corporate charters from Congress and or a bank was rejected in the convention. Madison, for example, knew that. It's one of the reasons why he's such an opponent in 1791 when Hamilton's proposal comes forward. The second bank is there. Maryland wants to levy a tax to drive the bank out of the state of Maryland. And the case comes to the Supreme Court, and we get this war horse. As number one, there is such a thing as implied powers, and those implied powers, drawing on what they call the sweeping clause or the necessary and proper clause, include if the end is legitimate, all means plainly adapted, otherwise not forbidden. Any student who's been subjected to McCulloch knows this phrasing from Marshall. It's very carefully calculated to say that Congress should be allowed to do that which it needs to do to effectuate the national interest. Of course, can Maryland tax the bank? No, the power to tax is the power to destroy, a phrase that Marshall stole from Daniel Webster's oral argument. And that would interfere with the ability of the national government to do what it needs to do. The size of the Maryland tax was not important. It was the principle. Now, one of the deep ironies of McCulloch is there's nothing actually in McCulloch that's new. The implied powers were put in place by the Supreme Court in 1805 in a case no one ever hears of, and certainly no common law professor teaches, United States versus Fisher. The notion of a document that is vague and needs to be filled in by the court surfaces in multiple places. Bank of the United States versus DeVoe in 1809. But what Marshall did was seize the moment. So you read McCulloch and you think Marbury is entering in from nowhere, implied powers. That wasn't true. Implied powers were already there. But what understood was twofold. First, the bank in 1819 was not well viewed. We had the panic of 1819, which people thought the bank caused. We had mis, mal, and nonfeasance revealed by a report to Congress in January of 1819. The bank was an enemy, and for the court to issue an opinion on implied powers saying the bank was constitutional, that was the second issue, this question of states and state rights, at precisely the point that McCulloch is being argued. By the way, 6 attorneys, 9 days of oral argument. Contemplate if that were the norm. If this morning when the court convened, they were getting ready to have 9 days of argument in the very first case. We don't do that anymore. But as the court is hearing this case, Congress, in the House in particular, is debating the Missouri question, i.e. slavery. One of the things the Southern states are now deeply afraid of is the implied power for Congress, if the Northern states can get some degree of control, to interfere with the institution of slavery. So the way that the Constitution is structured, and I don't want to dive too deeply into this, it was going to be an implied ability to interfere. That was a second reason with regard to the state rights issue, that McCulloch becomes a lightning rod and an important step in the Marshall Project of seizing the moment, issuing grand opinions like Marbury was, where he manipulated things. She did not mention that the Secretary of State who failed to deliver the commission was in fact John Marshall. Madison was his successor, trying to pick up the pieces left over from Marshall. And here's Marshall sitting in a case where he caused the problem. Things were a little different back then in terms of judicial recusal. So we have this project that begins with Marbury, is intensified with Peters, picks to McCulloch, which is right about the midpoint of a process that it then intensifies in 1821 with Cohens.
Right. And yeah, one thing that we should mention is that Spencer Roane and Marshall are continuing to fight each other. They don't believe it at Martin v. Hunter's Lessee. In Virginia, Spencer Roane is not just a member of the Chief Justice of the Supreme Court. He's also a member of what's called the Richmond Junto. He and his cousin, who is the editor-in-chief of the Richmond Inquirer, and every other important person in politics, business, government, law, form a political machine in Virginia that control, through their access to the press, the courts, government, and cash, who gets appointed and what the sort of organizing topics for civic engagement are. Over 2 generations of Virginia politics, they call themselves the Richmond Junto, and Spencer Roane is very much front and center in that. And and its organ is the Richmond Inquirer. Spencer Roane doesn't just make his opinions known on these major questions of national judicial concern through his opinions. He also writes under pseudonyms in his cousin's newspaper. And he does this on the McCulloch v. Maryland question. And there's an enormous back and forth between him and Marshall. Marshall also writes in under a pseudonym to try to defend himself in the newspapers. Personally, I think Spencer Roane gets the better of that exchange, just being a more stylish, incisive, devastating writer. I'm sorry, but I think Marshall is not as good at the ad hominem attack. And he continues it in the Cohens dispute. And importantly, the issue that Spencer Roane and everyone in the junto take with Marshall Court's jurisprudence is not the substance. They're not against the bank. In fact, certain members of the Richmond junto are officers of the Bank of the United States. And Marshall knows this. He complains to his friends in his letters that if he had dared strike down the bank, they would have been complaining about that. It's the reasoning he uses to uphold the bank. It's the implied powers reasoning, because this goes against their orthodoxy stemming from the Virginia and Kentucky resolutions and the stance that they took and their political genesis as Jeffersonian Republicans standing against the alien and sedition laws. That is the sort of genesis principles of their party and their understanding of what it means for them to be constitutional Americans. And they see in his implied powers arguments a real threat to that kind of American constitutionalism. And that's what they're standing against in all of these opinions and official channels and broadsides and unofficial channels and under pseudonyms of various kinds. So Cohens. Cohens came out of a lottery. Okay, lotteries were big business. Mark, we were just talking about this. There were lotteries all over the country, and one lottery act emerged from Washington, D.C. Congress that passes all the laws for D.C. Had authorized the municipality to raise a lottery for local public projects, and the Cohens family opened lottery ticket sales offices all over the country, including in Richmond. And shortly after they opened the Richmond office, the Cohens brothers were arrested under a law that made it a crime to sell lottery tickets without Virginian authorization, and fined $100. They were convicted. They appealed in Virginia. There was no appeal in Virginia, so they used Section 25 to take it directly to the Supreme Court. The first opinion about this case actually came out in the press under the byline of some New York lawyers who had a New York client who was nervous about the implications of this case for his New York lottery ticket sales using the same DC lottery. Because, one might think that the implication of McCulloch v. Maryland is Congress passes a law that, if you can establish a thing, be it a bank or a lottery, then you can open branches wherever you want. That might be a very natural implication of the McCulloch opinion. And so you had lawyers all over the country representing intrepid lottery salesmen writing this kind of argument in the press. And then the Richmond junto cranked into action in Virginia, writing counter arguments even before argument was scheduled in the Supreme Court on the case for the Supreme Court. In the meantime, Virginia debated whether or not to even send lawyers to argue, because they had never backed down from their position in Martin v. Hunter's Lessee. And when the Supreme Court sent down its mandate, saying, we have granted the petition of the Cohens brothers, it was published in the Richmond Enquirer as an outrage. Look at Chief Justice Marshall hauling a sovereign state before the bar of the Supreme Court, basically by the scruff of its neck, a sovereign state. And the Virginia Assembly debated resolutions and passed resolutions saying that Section 25 was unconstitutional. They finally did decide to send lawyers to represent them, but they instructed them to only argue the procedural question. They were instructed to only argue that Section 25 is unconstitutional and not to touch the merits. And once they had argued that the Supreme Court had no appellate authority over the decisions of a state court, they should consider their job at an end. So their lawyers went and did that. They did it using, very much the same arguments that Spencer Roane had used in the Martin case a few years before. And then Daniel Webster stepped up to the bar, making it clear that he was representing a New York client for the merits portion, and handled the merits part of the case. Marshall's opinion was comprehensive. Finally, he got to speak in his own voice and not by breathing down the neck of Justice Story. He started from, first of all, he answered comprehensively their textual arguments, their structural arguments. He took seriously every one of their detailed lawyerly concerns. Then he made historical arguments, original intent style arguments. He pointed out that members of the first Congress that had passed Section 25 of the Judiciary Act, many of them had been in the Constitutional Convention. Surely they thought it was constitutional. He also made these broader arguments about the nature of the document and of the compact, and arguments from logic about the inconveniences and the nature of sovereignty, arguments from political science. I think what's most notable about this case, and this goes back to something that Mark was saying about the McCulloch decision, is, again, these were all issues already decided. And so what's striking about the case is not that it broke new ground, but when I was rereading it again last night and saw that he mentions Martin v. Hunter's Lessee only at the end of a paragraph and in passing after he's already redone all the work. To a modern eye, it seems strange that he never relies on precedent, and one asks oneself why. And what emerges is it's because the Supreme Court doesn't have the stature at this point to say, this is the law because we say so. Much less can they say, this is the law because we said so. Okay? They have to prove it, again, from first principles every time. And he knows that he is dealing not just with a hostile competitor jurisdiction in Virginia, but also with a broad audience of other jurisdictions, eager to see who has the better argument. The entire legal world, his entire legal world, is hanging on these words, and his legacy is at stake on the strength of how well he responds to these very, very strong challenges to his arguments and his vision for the nation.
Again, if any of you go look at the old reports, the discussions of McCulloch and Cohens and everything, which were prepared by private individuals, you'll see before the court opinion, you'll see these extensive discussions of the arguments pro and con. Citations to precedent. And so the attorneys will say, we'll discuss these prior cases. Then the opinion comes down that Marshall writes, and you don't see any precedent anywhere. It's as if in each of these major opinions, we're starting from scratch. And that is entirely consistent with what she just pointed out in terms of the part of the project is to fashion a strong national government. Part of the project is to make the Supreme Court a respected player in the system, a player who is determinative in terms of issues. And so in the wake of McCulloch, you've got Andrew Jackson, and Andrew Jackson's basic theory of life is that's John Marshall's opinion. I don't care what he thought about the Bank of the United States. I think it's unconstitutional. And he then, with the assistance of Roger Brooke Tawney, launches the war on the bank in the early 1830s after they make a miscalculation about extending their charter. And it's part and parcel of this development of both national power and a powerful, or at least a respected, Supreme Court. Cherokee removal cases, John Marshall has announced his opinion, let him enforce it. Jackson probably didn't say that. But fast forward to where I sit, Arkansas in 1958. Dwight Eisenhower does not particularly care to enforce Brown v. Board, but Dwight Eisenhower does, because it's the law of the land. And that's the shift that Marshall is eventually able to lay the foundations for. It's not a complete shift at the time Marshall's on the court. I mean, Abraham Lincoln's first inaugural. Dred Scott is binding between the two parties. Otherwise, it's just something we can read and think about. He's just pointed out about how Marshall goes about this is just critical to seeing how interesting and important what Cohens does in 1821 in terms of continuing this process.
So I think we just have a few more minutes. We should maybe, Mark, maybe you should talk about what came next.
But let me add two things. Okay, one of them is one of the deep ironies of the 1821 term is right after the report of Cohens. Gibbons versus Ogden makes his first appearance in the case in the case reports. That's of course the Great Commerce Clause case decided in 1824 eventually. And what appears there is, oh, we do not have a final judgment from the final court in New York where a judgment could be had. Under Section 25, we have no authority to hear this case. But there's Gibbons lurking in the background, which is going to become yet another one of the final concrete blocks or bricks or pillars, whatever, in the Marshall Project. And that I think is important for those of you that want to further explore these kinds of matters is that part of the dialogue is the Supreme Court opinion, and part of the dialogue is the stuff that is published in the newspapers, the Algernon Sidney essays by Roane and the Inquirer, et cetera. But another place to go is the letters, the private letters of key actors. So you have Thomas Jefferson, for example, in the wake of Owen saying, I'm tired, I want to live my life, I'm not going to be involved in public affairs, in a letter to a guy named Hammond. But then privately waging war against Marshall, who in his letters to Bushrod Washington and Joseph Story says, I'm absolutely confident all of this stuff that's happening in Virginia is being generated by the llama on the mountain, Thomas Jefferson. This is him going after us yet again. You have Spencer Roane sending a letter to Madison saying, oh, great and glorious Madison, you're the voice everybody respects. I appeal to you to make clear what this should be. And Madison's reaction to both McCulloch and Cohens is not what Spencer Roane or Thomas Jefferson is going to anticipate. Rather, Madison is concerned that the Supreme Court is giving too much latitude to the legislature, to Congress, that it's not doing its job to curb the potential for excess on the part of Congress via its implied powers and that. But he also says, we need a single voice. We do not need these disparate voices breaking out. And when you start wading around in the letters, Joseph Story saying that basically he says everything they're saying in the Inquirer is just tedious and not even I can't even read it because it is so egregiously wrong in terms of what the vision should be. And so what I recommend to people who want to pursue this is wade around in the correspondence. Same way that when Jefferson says we are all Democrats, we are all Republicans, his inaugural address, we're united together, all for one for all, sort of like the multiple musketeers, the 13 musketeers, or however many states we had then. The very next day in a private letter, he's moaning and groaning about the Supreme Court, which is going to be this entrenched stronghold of the Federalists who will wage they're a subtle core of sappers and underminers. The public-private aspect of these debates is well worth exploring, and I've got tons of quotes I could give you from the letters that are just great fun. William Johnson, the one who Jefferson thought was going to help turn the court. Jefferson will start to engage. There's an exchange of 6 letters back and forth between Johnson and Jefferson that are very telling in 1822 and 1823 that people would greatly profit from reading. And it's particularly fun that they set up Gibbons and eventually Osborne versus Bank of the United States, which closes off some things that Marshall should have said in McCulloch and never got around to. But once you get 1824, leaving aside some stuff with regard to bankruptcy and everything, the foundations for a court that will eventually become, in most meaningful respects, supreme have been laid. Did they have that reputation? Did they have that authority at that point in time? No. But it's because of Marshall with Story, with Bushrod Washington, with William Johnson, who actually goes even farther than Marshall in Gibbons, that the basis for what we now have, which is the American system of judicial review. And by and large, people will moan and groan about what the court does, but when the court speaks, they believe it's something they need to listen to. And in both Congress and the branch, to the extent that it's not a constitutional decision, but rather a statutory one, they're going to obey. And it's very fun.
Well, I'm not, so for my part, I think that they may not have established it by that point. I think that the establishment may have been more a retrospective, a post-Civil War phenomenon. But I certainly think we're indebted to the strength of the opposition for the elaboration of principles that otherwise would have gone unsaid. If not for Spencer Roane and for the constant confrontation between an able opposition, an active, able, aggressive opposition from Pennsylvania, especially from Virginia, from Ohio and Osborne, and so on. We may never have gotten the full extent of Story and Marshall's exegesis of these rationale for the Supreme Court's supremacy and areas of mutual concern between the state and the federal government on the meaning of the Constitution. And then there would have been nothing to build on from this era in the 20th century when the political conditions were ripe to establish the kind of government that was so strong on the federal level, stronger than they could have ever imagined.
It's the essence of the idea that the court hears cases. You've got opposing parties debating and framing the issues. And in that dialogue of antagonistic parties, we sow the seeds for what will come. And you're absolutely right that Marshall needed Spencer Roane. Marshall needed the Hartford Convention in certain respects. Marshall needed those things to start to emerge, just as the post-Marshall or the transitional court needed South Carolina and the nullification thing. And notice Jackson, who doesn't like lots of what Marshall does. On the other hand, when South Carolina is going after what he as president can do, all of a sudden, that's cool. I'm on their side. It's great fun. It's like Jefferson's, I hate internal improvements in 1790, but when I'm president and can dispense these things, it's patronage and make people think I'm a lovely guy. I'll go ahead and do them. It's part of the fun of I tell my students simplicity is bad, complexity is stuff is complex and fast. Go on, but I think we probably Mr. Duff would has some questions in the queue. You're muted.
Thank you very much, Professors Peterson and Killenbeck. This was a fascinating discussion so far, and we will be taking questions from the audience. If you have questions, please type them into the Q&A section, and we will get to as many as possible in the time frame we have. A couple I had, and then I know we already are getting some, so it was a very stimulating discussion, and we're very grateful for that. How many occasions did the court have in the Marshall era? He was Chief Justice for 34 years after Marbury to rule on the constitutionality of a statute. You both alluded to the fact that there were underpinnings to Marbury and leading up to it and the articulation there. But how often did they exercise that muscle that was, we refer to as having been first decided in Marbury during the Marshall era?
Well, I don't think that he did it again. Mark, correct me if I'm wrong, but I think that the next opportunity was Dred Scott before the Civil War. Does that sound right to you, Mark?
Actually, there was a writ of mandamus to state authority case in 1821, but no one's ever heard of that. Quite frankly, I heard of it years and years ago and totally forgot about it.
What's that one?
McCulloch versus Silliman. It's buried in the back of the reports. The Marbury-based question, which of course, remember that in the wake of Marbury, the Congress goes back, and the Jeffersonian Congress goes back and completely revamps the structure and the many aspects of the judiciary, and the Supreme Court says that's cool. So one of Bruce Ackerman is one of his books rides this hobby horse pretty thoroughly in terms of that debate there. Pure constitutionality of statutes issues pop up from term to term, not every term, but that's part of the myth of the Supreme Court. I mean, that persists today, that the only thing the Supreme Court does is resolve gloriously sweeping constitutional questions. That wasn't true then. Lots of the cases that are in the reports in the early years are admiralty cases, prize cases, like land title cases. There's one case where the court resolves it based on something that was carved in the bark of a tree. It was one of the very first William Johnson opinions for the court, and contemplate that, here's the Supreme Court, not themselves personally going out and looking at the tree, but the issue is resolved because of something that's carved in the bark of the tree. But they do periodically come into and look at these questions of constitutionality. And for better or worse, much of what is done in constitutional law is this grand constitutional sweep stuff, of which we can go Marbury, Peters, Cohens, etc. But there's lots of other things underneath it that the court does that are important. They're not just important to the litigants, they're important to the structure of the country.
And of course, recall that the court passes on the constitutionality of a statute when it upholds it as well. And each of the cases we've discussed today involved upholding the constitutionality of Section 25, which were as dangerous for the legitimacy of the court and required as much courage and fortitude on the part of the justices and as much support from the executive branch as striking down a statute would. These are also expressions and exercises of muscular judicial power.
And if you get into Fisher and DeVoe, you see the court saying some things that are going to become the factors that are in the Ashwander. We could do this, but we're not going to, because it's cases from the 1800s, and it's just charming to see it there.
I found it very interesting, your observations about in the opinion writing, that they did not cite the precedents up front, but rather issued the opinions with their own, Marshall in particular, with his own viewpoints, and then got to the precedents. And you mentioned that this was used against them and the later administrations to single out that this is a Marshall viewpoint and not one based in prior law and so forth. Do you think that would have been different had he used what we now view today as a more traditional approach to it, that is, cite the precedents for your opinion sort of up front? It strengthens the opinion. Do you think there would have been less criticism of those opinions had he done that early on, or was it more important, as you've talked about today, for them to make clear that they had this authority up front?
I think that goes back to what Farah said in terms of would citing the precedent have done them any good if people didn't believe that what they had to say was worth listening to. And so you have McCulloch, and he writes a one-paragraph opinion based on what we previously told you in Fisher and DeVoe. Congress has implied powers, and the reaction to that is going to be, now you've made 3 mistakes rather than just one.
Right. An error doesn't become true by being frequently repeated is a line in one of Spencer Rome's opinions. you
Great
know,
line.
they're ready for it. I mean, one reason why Marshall didn't cite a lot of authority is not only because his own authority would not have been respected, it's also his style as a lawyer. He simply wasn't as technical, perhaps not as skilled as some of the other lawyers before the bar. You know, we read mostly Marshall opinions from this period. If you read a little bit more broadly, you see other lawyers are more our style of lawyers in that they cite authority for most of their propositions. And when you read Marshall, when he is feeling a little bit more oppressed, when he's Marshall the lawyer rather than Marshall the Chief Justice, or even Marshall sitting, on circuit and surrounded by his older peers. For example, Marshall issuing motions in the Aaron Burr trial. He cites a lot more authority. There he's being dictated to and even bullied by older members of the Virginia bar who are saying, listen here, youngin', I'm going to tell you what the rule of law is, and you better not make a mistake. And these are all of the leading people who have been around and have watched him grow up and make mistakes. In the motions he issues in that case, he cites a lot of authority. So it's not just stylistic. It's not just a choice. It's also stylistic. And so to narrow the question, it's why didn't he cite himself? He didn't cite himself because that wouldn't have mattered. Why didn't he cite any authority? Arguably, it's because he wasn't that great of a lawyer, as lawyers went for this period.
Contrast that with Joseph Story, who becomes the first professor of law at Harvard College, generates, and just using parchment and a quill pen, generates all of those treatises. I mean, Story's commentaries on the Constitution in 1833. I couldn't do that today with my word processor, the 3 volumes. He's doing it, churning them out. So part of what happens is the profession, so to speak, starts to change, and the technique of legal discourse starts to change. But it's a fascinating thing to look at in terms of how the court goes about its business.
Question from the audience was, dirigiste economics, factories and speculation, just naturally held in suspicion by Jeffersonian agrarians from the get-go, of whom John Marshall was one.
Jefferson's a complicated individual and a great Jefferson fan in some respects, but his vision of the noble farmer, etc., that animates some of his writings, and particularly if you go into his notes on the state of Virginia. The agrarian economy of the 1790s, 1800s, 18 teens is part of the backdrop of what's going on in the nation. And the transitions that start to occur as the United States becomes more able to assert itself as an economic force. We're not dependent on Britain. We are starting to generate industry in the northern states and plantation economy in the South, which is going to generate large quantities of cotton and tobacco and stuff, are backdrops, and they're tied up in some respects with state rights. But I don't think Marshall would be counted as one of the Jeffersonian agrarians.
I didn't think so either.
Intensely aware of that backdrop, particularly given the nature and structure of the Virginia economy. One of the things you have to keep in mind is the increasing division that starts to be set up between arguably North and South, not on constitutional issues and or secession and or nullification and or whatever, but just on the structure of those societies. You bring that to bear.
Did John Marshall and the Supreme Court justices have court reporters or scribes to write up their documents and opinions in those days?
Oh yes, and we're tremendously indebted to them. We still name the early reporters under their names: Peters, Wheaton, how. And there was even some early litigation, wasn't there, between two of the Supreme Court reporters, a copyright issue, an early, even an important copyright case about who owned the product of one of the first reporters, whether it was the person who actually made the reports or the person who took over the job. Can't remember the details of that case, but oh yes, they were very proud of their work. They did a great service to the nation. And they're, detailed records that we still rely upon today.
It was, for example, post Cohens, Marshall sends Henry Wheaton a letter saying, as you prepare your report of the case, please be advised, these are some things you need to correct that were errors. And then he says, oh, by the way, please make it absolutely clear that we had a final opinion from the court within which it could be issued, which allows us to use our Section 25 jurisdiction. And what he was doing there is, after the opinion was written, responding to the accusation that is part of Algernon Sidney's screed against Cohens, that it was a feigned case. It was friendly litigation, and it was not really a true case or controversy. So and one of the things that you have to tell people when they read modern Supreme Court opinions, if the Supreme Court of the United States tomorrow issues an opinion citing Cohens or McCulloch or whatever, they're not going to use a U.S. site. The tradition in the Supreme Court is we're cite to the original reporter. So it's not going to be McCulloch versus Maryland, 17 U.S. parens, et cetera, 306. It's going to be to the original reporter. And when my students see that, if they actually read United States reports, they're like, what's this stuff?
If I'm not mistaken, it was fairly lucrative too, I think, for the reporters early in the history of the reporting decisions. But
that's why the Henry Wheaton copyright litigation was interesting and important.
Exactly.
You can imagine they would sell subscriptions in advance, and every important lawyer would want to buy in advance a copy.
Right.
So it was a lucrative job.
The court in 1821 heard their first the First Amendment case, Anderson versus Dunn. Can you talk briefly about that case?
It's a fun case because lurking within that is, again, issues of implied powers. It's a William Johnson opinion, which I would have talked about a little more, because it's one of those important cases in terms of the progression of implied powers and the manner in which Congress goes about its business, where Johnson is staking out a position diametrically opposed to that of his patron, Thomas Jefferson. Now, part of the problem with any First Amendment issue in this era is that it was generally understood to be a provision that allowed you to speak, but reserved to government the power to punish you for your speech. They adhered to the notion set forth in Blackstone's commentaries that freedom of speech meant freedom from prior restraint. That is the licensing system of England in the 15th and 16th centuries. And so there's a wonderful book by a professor from the University of Texas called Free Speech in the Forgotten Years, which basically captures the reality that First Amendment free speech law, until you get to 1919, with the process beginning with Abrams and Schenck and Gitlow, the government's going to win, the speaker's going to lose. So to speak of any First Amendment free speech case prior to the 1920s is to you've got to be very, very careful about where the court is going to go with that stuff.
Well, we have time for one last question, and I'm going to pull this one up. What is your favorite obscure case from this era?
That's an excellent question. Well, actually, I think now it's U.S. v. Peters, because the full story is so exciting. This was not just a privateer in the service of the U.S. Who was using his ship in service. He was a Connecticut sea captain who was captured at sea and then impressed into the service of the British Navy, stolen down into Jamaica, and then with fellow impressed sailors, used in a naval ship that was taking supplies up to New York to serve the army of the imperial troops. When he and his fellow enslaved captives rose up against the British Navy, took over the ship, and sailed it triumphant toward Pennsylvania, where they were themselves captured by 2 American ships and frog marched into the harbor. And then that was what spawned the litigation about, okay, so who actually captured this ship and who deserves the booty? Was it the sailors who suffered all of this torment and rose in glory to serve their country? Or is it the ones who came in at the last minute and cleaned up when all the hard work was done? And there's so many exciting twists and turns in that case, which one finds in almost every one of the cases from this era one looks into. But because this is a tale of the high seas that goes all the way down to Jamaica and back, I think it's got to be my favorite. It captures the imagination.
That's
and,
great.
and it's Pennsylvania, and Pennsylvania's James Wilson. His famous speech in the State House yard. He's one of the strong nationalists, but it's Pennsylvania. It's not Virginia. It's not South Carolina. So it's a favorite of mine. I think United States versus Fisher, if you want to talk about an obscure one that con law professors, et cetera, don't teach, is a fascinating case because of what it says both about issues of debtors and bankruptcy, setting the stage for when John Marshall will eventually in 1828 issue his only dissent in a constitutional case. But it also talks about principles of interpretation and what we do or do not do with regard to a Congress and what a Congress can do. So it's obscure ones that are worth playing with. I can't remember the name of the case, but it might be Hiddekeeper's Lessee or something. Let's figure out what the law is and the land title is by looking at the bark on a tree. I mean, if I were to go into class and say that, the students would think, what have you been drinking today, Killenbeck? Where did you make this up? Stuff like that happens.
Well, this has been wonderful. I want to thank very much Professor Farah Peterson, Professor Mark Killenbeck for their engaging conversation today. Isn't it wonderful? It's 200 years ago, and here we are today, the first Monday in October, with another very interesting term of the Supreme Court on hand, but looking back 200 years and seeing this rich history of the court and the issues it wrestled with. And you can draw analogies certainly with issues that we wrestle with to this day, and the fabric of our country and where the power rests and between and among the branches and on federalist kinds of cases. Fascinating. And I'm sorry, go ahead, Mark.
Appropriate thing that I can't help myself on. To the extent people are interested in Spencer Roane and these cases, there's a judge in Virginia, a guy named Johnson, who has just published a book that is a biography of Spencer Roane. I'm blocking on the title. Farah might have it sitting there with her, but I strongly recommend it. It's a nice treatment.
Irreconcilable Founders.
Yeah. The other thing I'm going to say is there'll be a book coming out in year 2022 by a professor at the University of Chicago, Allison LaCroix, that is going to look at the antebellum court and constitution in the national struggle. And I have seen a chapter of that. Farah has seen some of it. Keep your eyes out for that book because she is an extraordinary scholar, and this is going to be an incredibly great book to fill in much of what the two of us have been trying to sketch out in our own indomitable way. Look for that book when it comes out.
Enthusiastically seconded and endorsed.
Well, we are very grateful to the two of you and for your endorsements for other works like the ones you've just endorsed. It's what our historical society really lives for, is educating. It's part of our mission, and you have contributed wonderfully today to our mission, and to our country's history and its study of it. It's crucial, I think, to our future. Thank you both. Because this is a new format and a new experience for the society and our members, a survey is going to go out later this evening to everyone who registered in advance. Please do respond to that survey. We want to make these programs as useful and accessible to as many people as possible. Some of this was born during the pandemic when we weren't able to meet in person, and we increased the number of these programs, virtual programs. The response has been so positive so far. I know we're going to continue those post-pandemic, and we're grateful to all those not only who have participated in the discussions, but to our audience, which continues to increase. Very pleased about that. For more information about the Supreme Court Historical Society and future events, please visit our website at www.supremecourthistory.org. And with that, I want to thank everyone for joining us today, and we are adjourned.
Thank you for having us.